Good afternoon. We want to thank you for participating in the video oral arguments. Helps us move our cases along and helps you move your cases along too. So it's a mutual benefit. We'll have court just like usual. Just the oral arguments will be the same, only we're on video instead of in person. The arguments are being recorded and they are being live streamed. Mr. Hivner, would you please call the case?
Jack W. Gibbons et al. Versus Kyle Bennett et al.
Let's see, Mr. Taylor.
Yes, Your Honor. Dudley Taylor from the Knoxville Bar, representing the appellants, Jack Gibbons and Top Gun. And this is awkward as heck for me, but I hope I don't stumble too badly trying to use the technology. I would like to start just by briefly letting the court know that in my view, we proved in this case the wisdom of something that this court articulated in a recent case, the September 14 case of Bosch, B-O-E-S-C-H versus Holman. The court noted, and the trial court had noted, that the trial was separated by about 6 months, 2 days. In this case, we separated the beginning to end by about 5 years, maybe more, and we had multiple cases, so difficult, or so multiple hearings, it was so difficult, Your Honor, that we really had difficulty tracking down court reporters. A couple had moved away. But with that, Your Honor, I would move on to the issues. We identified 5. Obviously, some of them are more important than the others. I will just attempt to hit the high points, if I may, with the understanding that the court will stop me and ask me questions whenever it desires. The first issue, Your Honors, is it had to do actually with the interpretation of the contract. We called it the STA, the Stock Transfer Agreement. And there was language in that said that the corporation was entitled to all assets that were either bought by or used in the business of Top Gun. And that led to the first issue. There were several vehicles that the plaintiffs, appellants, believed had been used in the business. In fact, they had been used in the business. In our view, the trial court interpreted used in the agreement as meaning something other than promoted. It was undisputed that these vehicles were used to promote the business. They were taken to auto shows, they had stickers. Also, there was no dispute but that the vehicles were maintained by the corporation. When we had the evidentiary hearing on this, members of the court, the trial court said that there would be 3 issues that we would present evidence on. One was whether Kyle Bennett, the appellee, had signed tax returns under perjury that claimed depreciation deductions for any of these vehicles. Number 2 was whether Kyle Bennett had signed off on a lease agreement through which the corporation paid Mr. Bennett and his wife to garage all of these vehicles. They had a 9-bay garage at their home. Then the third was just a general issue of whether the vehicles were marital property. The court found for the appellants on the first 2 issues, Your Honor, well, at least in terms of 3 of the vehicles, that Mr. Kyle Bennett had signed under penalty of perjury tax returns claiming deductions. The court also found that the corporation had paid $6,000 a month, I believe it was $6,600 a month for rent space. But yet the court concluded that the vehicles were marital property. And as I set out in some detail, I believe the court was just felt that it could not go away from an agreed order that had been tendered in the separate case that was consolidated with this. But in any event, I respectfully submit that under the normal standards of contract interpretation, it would be applicable that with the facts that were admitted that these vehicles were the property of Top Gun. Members of the court, I pleaded an alternative to that, which is that if the trial court determined that the vehicles belonged to Mr. Bennett and his wife, then the corporation was entitled to recover all of the expenses that it had paid, including garage payments, registration fees. They paid like $130,000, I believe, on a Lamborghini. There was a souped up Super, I believe it was, that had spent about $80,000 on. But in any event, that was our alternative issue. The most important, well, let me just remind the court that although the most important point is the breach of a covenant to not compete and the damages, there really was no dispute but the fact that Mr. Bennett did compete. He had the covenant. It was for 5 years. It was within 100 miles of Top Gun's place of business. And when we had a hearing on our motion for temporary injunction, Mr. Bennett conceded during that he didn't really deny that he competed. He just believed he had the right to do that because Mr. Gibbons had breached the agreement first. The court heard that proof on the application for the temporary injunction and rejected it. In fact, it concluded that there was no proof that Mr. Gibbons had breached any aspect of it. It was confusing then to hear the trial court conclude, or not to hear, but to read in the memorandum of opinion that it was difficult to determine who breached first and how. But the trial court didn't determine that during the hearing. And there was a second hearing when the defendants, appellees, moved to dissolve the temporary injunction. And once again, after the hearing of the proof, the court rejected that. So I think that's one factor that's attributable to the matter being stretched out so long that by that time, 3 years had elapsed. And I don't know if the trial court was upset with us or not, but that statement in his memorandum of opinion, Your Honor, was clearly contrary to what he had found. The biggest issue, of course, is damages, whether we proved the existence of damages sufficient so that there should and could have been a reasonable estimate, even if the court did not accept the testimony of our expert witness. Our expert witness as to the proof of damages, Your Honor, he was a fact witness as well as an expert witness. He certainly qualified as an expert, but he had also done the accounting work for Top Gun for 2 or 3 years when it was operated and owned by Mr. Bennett and his wife. And then he came back in after the transfer of ownership and did work again for Top Gun while Mr. Gibbons owned it. The trial court, Your Honors, I think was most bothered by the fact that in the evaluation, the expert, Mr. Day, concluded that the loss of business was immediate. In effect, it's like a straight line loss. But the trial court did not take into account the fact that it was admitted that Mr. Bennett had plotted to shut down the business before selling it to his then father-in-law. That testimony was offered by Jeff Browning, who had worked for Mr. Bennett at Top Gun and then later worked for Mr. Gibbons at Top Gun and then was hired away by Mr. Bennett again. But with that preparation, if you will, setting up Mr. Gibbons to walk into business that had been shut down, then it seems to me to be a reasonable conclusion that that is why there would be an immediate decrease of business in something with a straight line, as opposed to just being no way to determine what caused that loss of business and loss of profits for Top Gun. Mr. Gibbons himself testified as to the loss of car dealerships. The business generally consisted of 2 types of work. One would be Your Honor, all I can call it is souping up of vehicles. They take these big Ford Rams or Dodge Rams, whichever it is, and put suspension bars and all of that in so that they end up being about 5 or 6 feet off the ground, at least it seems like. So that was one avenue of business. The other avenue of business was the eBay business that was sold to faceless people across the country. And again, all of that was shut down, at least on a temporary basis. Mr. Gibbons went back in and tried to get it started back up. And then by May, Mr. Bennett was back in the area. He had competed from the beginning, but he initially competed, so he said, up in the Tri-Cities area, which would likely have been outside the 100-mile radius, just depending on, I guess, whether you use Google or something. But that is where we respectfully submit that the court erred by not taking into account the preparation for that, which put Mr. Gibbons at a distinct advantage over and above the competition. So in our view, Your Honor, in the absence of any other proof on the part of Mr. Bennett that he did not take any of these dealerships and did not shut down Top Gun, and he did not testify to that, then we think that the court should accept Mr. Day's valuation of lost damages. If not, then, Your Honor, based on the Tennessee judicial history relating to finding of damages in this area, says, let's see, I guess the primary case that I relied on was the Wagoner case, and they're cited with full citations in the brief. But it says that the courts will allow recovery for breach of a contract even when the exact amount of damages is impossible to prove. That's the Cummins versus Brody case. Otherwise, the courts would be powerless to help some wrong parties. So it says uncertain and speculative damages are prohibited only when the existence of damage is uncertain, not when the amount is uncertain. That's what we believe we have here, Your Honors, that we have certainly an admission of competition in breach of the contract. We have a loss of business. We have damages. What is the amount? The trial court himself noted, I think, during his memorandum opinion that, or in one of the earlier opinions, that it's always difficult to prove damages in a case like this, and that's why the best remedy is to get an injunction early on. Well, we tried our best, Your Honors. We filed our motion for entry of a temporary injunction on, it was early of 2015, and we did not get it heard until 2016. And only then, after we filed a motion to expedite the hearing of these motions or to expedite the hearing of the trial. And neither of those occurred. So we certainly tried to do what the court said we should have done. As it turned out, I don't guess it would have made any difference if we had gotten our injunction in the day after the case was filed, because Mr. Bennett simply was not going to abide by any of that. I see my time is nearly up, so I'll reserve my additional comments for rebuttal. Thank you, Your Honor.
Thank you, Mr. Taylor. Mr. Howard.
Good afternoon. Thank you, Your Honor. Lewis Howard of the Knox County Bar. I represent Ken Bennett and Kyle Bennett in this appeal. I'll try to address the issues in the same order counsel went through them. Excuse me. With respect to the vehicle issue, there were, the way that came about through an evidentiary hearing, there were cross motions for summary judgment on that issue, primarily arising out of the fact that Mr. Gibbons had entered into an agreed order agreeing that those vehicles were the marital property of Kyle Bennett and his then wife, Rhonda Bennett, and later took the position through the filing of the complaint in this case that was consolidated with the case in which the agreed order had been entered, took the position that those were corporate assets. So there was an extensive evidentiary hearing based on cross motions for partial summary judgment. The court had both counsels submit proposed findings of fact and conclusions of law, and the court adopted all 47 of the findings of fact that the Bennett submitted. And among those findings of facts were that Mr. Gibbons had conspired with his wife, his daughter-in-law, Rhonda Cox, and another relative, Troy Bull, to transfer titles to these vehicles prior to the time that the stock transfer agreement was entered into. At the time that Mr. Gibbons signed the stock transfer agreement, the court found that he was hiding two of these vehicles in his vacation home in Sevier County. he also testified that he engaged in that activity because he believed these vehicles were marital assets and he wanted to preserve the assets for Rhonda Bennett and did not want Kyle Bennett to be able to dispose of these assets. So there were a number of findings in that regard. More particularly, the court also found that these vehicles were not listed on Exhibit A to the stock transfer agreement as being assets of the corporation. They were not purchased by the corporation. The corporation had paid some expenses over the years on these vehicles, and that part of the proof also was that Mr. Gibbons, after he executed the stock transfer agreement, borrowed money from Pinnacle Bank and executed 3 security agreements and 3 powers of attorney in favor of the bank, using these vehicles as collateral and stating to the bank in those documents that he had good and marketable title to these vehicles. So there was significant, in fact, overwhelming material evidence that the court found in connection with the evidentiary hearing on the cross motions for partial summary judgment that the parties to the stock transfer agreement did not intend for these vehicles to be corporate assets. So I know counsel has taken issue with the court not making specific findings in its memorandum opinion, but the memorandum opinion that was entered by the court in connection with the evidentiary hearing adopted all 47 of the findings of fact that I've just gone over, most of them, and a few that Mr. Gibbons had submitted. So there was substantial evidence with respect to ownership of these vehicles and the fact that they were not corporate assets. With regard to the issue of expenditure of corporate funds, that issue was, there was never any authority cited to the court, and there was never any legal theory articulated by Mr. Gibbons or Top Guns as to how they would be entitled to recover any of these expenditures. There was no proof put on at trial whatsoever with respect to that issue. There was proof put on during the cross motions for partial summary judgment with respect to various expenditures that the corporation had paid for insuring the vehicles, some partial fees for storage of the vehicles, but none of that information or none of those exhibits were introduced at trial. And again, this issue was just simply never developed by Mr. Gibbons or Top Gun at trial. With respect to damages, the sole witness at the trial on damages was Jeff Day. And Mr. Gibbons and Top Gun had played, hide the ball for about 3 years with Mr. Day. They had disclosed him as a fact witness, and I had sent discovery regarding expert witness testimony, documentation, whatever they were relying upon, and they had repeatedly represented to the court and to me that they had no expert witness testimony. Shortly before the first scheduled trial, they disclosed Mr. Day was now going to be an expert witness, and the court ordered Mr. Day to produce documentation. It resulted in a delay of the trial, I think 2 delays because of a problem with another witness. And ultimately, Mr. Day was allowed to testify. And what Mr. Day testified to was the fact that he had reviewed tax returns of the corporation. And based upon his review of those tax returns, along with some general ledger statements, he determined that the corporation had suffered damages of approximately $2.2 million. That was the extent of his report. His actual testimony was that he had no idea how that loss occurred. He could not attribute that loss to anything in particular. I asked him specifically if he had any personal knowledge of any lost profits from customers no longer utilizing the business? He said no. And in fact, he testified that the business, once Mr. Gibbons began operating Top Gun business, that it started losing $413,000 a month. The primary loss that he attributed that to was the lack of internet sales, which Top Gun did not engage in through Mr. Gibbons. They had done quite a bit of internet sales when Kyle Bennett ran the company. He attributed a large percentage of those losses to the lack of internet sales. Jeff Browning, who testified, was the general manager of Top Gun at the time that Kyle Bennett ran it, and he stayed as the general manager for about a year after Mr. Gibbons purchased the company. Jeff Browning testified that there were substantial debts of the corporation that were not paid to suppliers, making it difficult to get supplies in to finish up vehicles, that Mr. Gibbons directed Mr. Browning not to pay certain vendors because of cash flow problems that they were having. And so there was substantial evidence from which the trial court determined that any losses that that Top Gun would have suffered were not the direct and proximate result of any competition by Kyle Bennett. The court also found specifically that Mr. Bennett, Kyle Bennett, did not set up a competing business within 100 miles of Top Gun until June of 2013. This transaction occurred in November of 12. And Mr. Day, who was, again, the only witness to testify as to any damages, Mr. Day occurred that at the rate of losing $413,000 a month, that Mr. Gibbons and Top Gun incurred losses of $2.4 million, more than they were claiming as a result of the alleged violation of non-compete. They lost $2.4 million within the first 6 months of operation. And so the court correctly found, based on that testimony from Mr. Day, that there was no proof whatsoever, no proof of any damages that Top Gun sustained as a result of alleged violations of the non-compete. And I'll remind the court, and we pointed out in our brief, there was not a single customer or former customer of Top Gun that came to court to testify that said, I used to do X amount of business, now I don't, and the reason why is, because I'm doing business with Kyle Bennett. And Mr. Gibbons himself offered no testimony. He made an offer of proof as to testimony. He made an offer of proof as to loss of gross sales from a couple of car dealerships, but he could not tell the court what the lost profits were, why those customers quit doing business, and had no personal knowledge whatsoever of the information. He was testifying off of a piece of paper that had been given to him by a bookkeeper. So there was, again, substantial evidence and findings with respect to these vehicles, and there was just a simple failure to prove damages under the requirements of Tennessee law. There has to be, in order to get damages for violation of a non-compete, the measure of damages is lost profits. And there was no evidence whatsoever of any lost profits. Looking at the evidence in the light most favorable to Mr. Gibbons and Top Gun, there was speculation that damages occurred because there was a drop in sales. But again, Mr. Day could not and did not testify as to any proximate relationship between those losses and any conduct by Kyle Bennett. And I don't want to argue anything else unless your honors have any questions for me.
I Don't see any questions. So thank you, Mr. Howard.
Thank
Mr.
you.
Taylor, you have 3 minutes.
Okay, thank you, Your Honor. First of all, I'm sorry, I think I shifted this. I think Mr. Howard said that there was that we being the appellants denied that we had an expert. We disclosed Jeff Day early on. We disclosed him as a person who was a fact witness as well as being qualified to render an expert opinion. The opinion that he rendered at court was based on an expansion of a report that we turned over to Mr. Howard and the defendants considerably prior to the final trial of this case, at least 2 years before the time that the proof was put on as to Day's testimony. Let's see. Well, in any event, I noticed that I guess we have the basic issue of whether we established that there were damages, but we were not able to establish with certainty the amount of the damages. I think that Mr. Howard would have you believe that there was simply no proof other than Day's testimony. Well, Day's testimony was the only proof as to the exact damages by his calculation, his methodology, but there was testimony from Mr. Gibbs as to the loss of car dealers. He could not identify the specific loss on the internet sales, but that was the other aspect of it. It is my recollection that Mr. Gibbons testified as to the loss of 7 new car dealerships, and that he offered specific testimony as to the loss of gross income and net income from Lance Cunningham Ford. His testimony, to my recollection, was that it was 400,000 of gross sales in the year 2013, and that netted 120,000, and there was about 5,000 of sales in the next year, 2014, and nothing after that. And there was proof in the record as to the fact of Mr. Bennett soliciting these folks and actually doing work for them. Since I'm so limited on time, I just simply need to make up this point that the inducement to breach contract was just disposed of by the trial court without any comments. He just said, we're dismissing this along with the rest. But literally, every element was laid out in the record to show all of those elements satisfied by Mr. Ken Bennett. I could understand if the court said, well, I'm not going to award any damages because I don't think you've proven any underlying damages. But the fact is that we did establish an inducement to breach contract, the only issue being the amount of damages. Mr. Bennett ignored the non-competition. He ignored the injunction. He agreed that he was in contempt, and there was no justification for that. Your Honors, I'm over, and I'm sorry. I appreciate your attention, though.
Thank you. Thank you both. Mr. Hivner, would you recess court until our next hearing?
This honorable court is now adjourned for the day. Counsel, you may leave the meeting at this time.
I'm trying to.